Good evening to everyone in Brussels. I'm Peter Swire. I'm a professor at Georgia Tech in Atlanta, Georgia. And I've enjoyed coming to CPDP every year for quite a number of years. And I'm sorry we can't be all together in the venue again this year. In any event, welcome to this event called Data Portability, Competition, Privacy, and Cybersecurity. That's a lot to cover in one panel. I'll introduce our four speakers in a moment. But as background, data portability and the related idea of data sharing have become very important issues, in part because of the attention given to digital platforms and their governance, in part because of legal developments such as GDPR's right of data portability. So there's been intense scholarly and public policy issues devoted to this. I've been one of the people writing about portability for almost a decade now, and recently wrote an article called The Portability and Other Required Transfers Impact Assessment. And then it looks at these issues of competition, privacy, and cybersecurity. And the attempt there is to take insights from competition law. In competition, we want portability to help things like preventing lock-in. We want portability to address network effects, to address dominant firm behavior, to address barriers to entry. We also would like portability so individuals have control and autonomy and free choice over their data. But on the other hand, if portability is done in the wrong way, it could lead to privacy problems. Somebody could maybe take my data without my permission and send it to other places. And portability can happen without cybersecurity. That can happen if there's bad authentication and somebody fakes being me. Or cybersecurity problems could happen if there's not secure transfer of data between point A and point B. So portability draws on these different intellectual disciplines, including competition, privacy, cybersecurity, and fundamental rights. And so how we organize that and how we think about that is important, as the issue of data flows are so central to our society. So with that as a very brief introduction, I'd like to introduce our four speakers for today. I feel very privileged and fortunate who we have with you. The first person to speak, and I'm glad to see technically we've got him back, is Malte Beyer-Katzenberger, who is team leader for data-driven innovation in DG Connect in the Commission. And as you know, the Commission's been putting forward many initiatives around data society that he'll be able to tell us about. Second, we'll have Professor Wolfgang Kerber, who is in Philipps Universität Marburg. And Wolfgang has been focused on cars. So if you think about the modern cars that we're moving towards, with enormous amounts of data flow between different apps in the car, what will the rules be for portability, or will instead things be locked up behind fences and not used as much as we'd like? Our third speaker will be Professor Nizan Pakin, who's a professor at Baruch College in the Zicklin School of Business in New York City, USA, and she's joining us today from Israel. And Nizan's an expert in financial services. In Europe, there's the Payment Services Directive I and II, open banking in England, similar initiatives in many other countries, including the US. And so this is an important sector where portability, being able to get your financial data where you want it, is important. And fourth, we're very fortunate to have with us Régis Chatelier from the CNIL in France. And Régis, his title is Innovation in Foresight Project. What a great job to have foresight as part of your job description. I think that's very interesting. And he'll be able to provide us from the CNIL and fundamental rights perspective, some observations from the first three speakers. So as that as an introduction, thank you people for joining us. We'll be able to look at questions and comments online if you send them to us. And Malte, please go ahead. Yes. I'm hearing Malte's comments. I'm sorry to the audience for any difficulties technically.
The data for and what your pumpkins you need by being to stuff. Still discussions will portability across the data cloud wireless again to take for the personal data have and the reporting on the era of it essentially the technical that is the up and start with identification also physical more
If you want to use the portability right well, we certainly have to face that. And one way I think
Okay, Wolfgang, please go ahead and put up the screen for Wolfgang. We're sorry.
Hello, I'm very happy being here and being invited to this panel. So I will talk about data access in connected cars. And we know that data access and sharing is can have benefits for innovation, competition, but also for empowering consumers. And you can have on one hand voluntary solutions, for example, by reducing transaction costs for data sharing. But mostly the question is whether we need mandatory solutions and what kind of mandatory solutions. So we can have data access obligations, for example, based on competition law. We can have sector-specific regulations, and we can have data portability rights as, for example, Article 20. Now, from a Connect perspective, we always have to analyze the benefits and costs of data sharing, and therefore there is always a question whether data sharing is justified at all, and if, what is the most suitable instruments and how to design it specifically. Now, my example is now data governance problems in connected cars. Now, currently in Europe, you have the so-called extended vehicle concept of the car manufacturers. That means that all data that are generated in connected cars are directly transmitted to proprietary servers of the vehicle manufacturers, and therefore they have exclusive control first on the access to the in-vehicle data, but also technical access to the car. And this leads to a gatekeeper position, and they can use this gatekeeper position for controlling all secondary markets and for close independent service providers. And this has negative effects on competition, innovation, and consumer choice. Now, the independent service providers and consumer associations, they demand a regulatory solution for this problem, and this is a discussion for some time. Now, there are other solutions in the discussion, and one is a so-called shared server. This would mean that also data are directly transmitted to a server which is not under the governance of the car manufacturers, but under the governance of a neutral entity as a kind of a data trustee solutions, and they can give then access on a non-discriminatory basis, for example, to all stakeholders, including the vehicle manufacturers. The other option is so-called open interoperable telematics platforms. There, the data are stored in the car, and the car users are in control of the data and can give access to the data and access to the car. Both other solutions would eliminate the gatekeeper positions and therefore solve the competition problems. And there was a comprehensive study commissioned by the EU about this, and this came to a clear result that both solutions would be superior to this extended vehicle concept, and also the security problems could be solved. The EU Commission has acknowledged the problem, but so far there is no solution, but they are planning a reform of the type approval regulation. I come back to this. Now, this example of connected car is only one example really of a broader case group. And we know this also from smart agriculture, for example. So where you have a manufacturer of connected devices that has exclusive control of all the data produced in the device and technical access to the device, and this leads then to competition problems and data access and ability problems, and can lead to less competition innovation. And also it can lead to a de facto appropriation of the generated data by the manufacturer of the device. That's exactly what's happening in the car example. Now, what are solutions in the connected car case? Now, there are a number of options. So one possibility would be data access obligations based upon competition law. For example, there is a new amendment in German competition law, but you could also think about the Digital Market Act using new provisions. The problem with this is that in the connected car case, this is difficult to enforce, and it's not applicable to interoperability problems. And the car manufacturers would not be at trustees of the Digital Market Act, for example. Then you can have data trustee solutions where, as I already have seen, the car data can be put in data pools under governance of a neutral data trustee, and they can give access to this data. And this is a very interesting aspect that should be explored more. But also here it's not clear about interoperability. And this is another problem here. And then we have sector-specific regulation and data portability rights, and this I will discuss in the next slides. Now, the advantage of sector-specific regulatory regimes is that it allows for much better tailored solution, because the problem is that this has to be tailored to specific economic and technological conditions, to specific market failures and security and privacy problems, which might be very different in different contexts. And the regulatory approach also allows for setting ex-ante rules. And so if you look how a sector-specific governance regime might look like, then it would entail a certain number of elements. Very important is the data governance solution itself. So who should control the data? Who should have access to what kinds of data and under what conditions? Then you need solutions for interoperability and standardization, and on two levels. One is data interoperability. That's exactly the discussion about common data formats and technical interfaces for data exchange, so APIs. But you also need, especially in the connected car, interoperability with complementary products and services, and this is on a different technological level and much harder to implement. Then you need minimum standards for safety, cybersecurity, and privacy. You can do this also with certification of service providers. And you also might need rules about fair fees, model contracts for data access, etc. And all of this really we have also in the PSD2 regulation, and is a thick bundle of regulations. Now, the interesting thing is that such a kind of a sector-specific regulation we already have for a long time in the automotive sector. And this is a type approval regulation. And this is a regulatory regime for mandatory access to essential technical information for repair and maintenance services. And this was exactly done for protecting competition on automotive aftermarkets, because this is an old problem. If you look at these, the current sector-specific access regulations, that you already see that's a front-like solution for access to essential technical information. You have rules about reasonable fees, standardized formats. You have technological regulation, because all cars need to have an OBD adapter where you can get access to certain diagnostic data. And you have also security regulation, because there are certification requirements for independent repairers if they want to repair security relevant car parts. The problem is that this regulation is so far not updated with the new technology of connected cars. And we have looked in a separate paper in this, and there is no access to connected car data with this regulation, and also no interoperability for new remote services, for example, remote repair and maintenance services in the car. And from that perspective, this does not work. And one option is now really to extend this regulation for allowing access to all data that are necessary for other service providers. And this can be done by really reforming this type approval regulation. And also data trustee solutions could be a part of this. Then I would like to talk about data portability rights. You know, there's a right to move, share their data of individuals and firms from one firm to another. But it's always a question, what is their data? And what is the scope of portable data? And what are conditions for portability? Now, there are privacy law-based data portability rights. That's exactly Article 20 GDPR. But the problem is this has so far not helped for solving competition innovation problems, and therefore we have a current discussion how to make it more effective. And there are some proposals about continuous data portability and mandatory technical interfaces. But you can have data portability rights also outside of privacy laws. For example, the Australian consumer data rights approach, portability of consumer data, and also in sector-specific regulations. So what we looked at in another paper is whether the data portability right of Article 20 GDPR can solve the competition innovation problems regarding to connected cars. And the result of our research is very simple. It does not work. And also, as the proposed reforms can only help a bit. And also after these reforms, this will not work. So we have no access to real-time data, which would be necessary for repair services. You have no obligation for enabling technical feasibility of data portability. There's an unclear scope of portable data. And there's a much too narrow scope of portable data because non-personal data and inferred data are not included. But service providers might need aggregate level data for innovation, for example, for training algorithms. And this cannot be provided by the data portability right of Article 20. There's no obligation for interoperability. There's no provisions for ensuring safety and security, and the transaction costs are much too high, and therefore this will not work and it's not sufficient. So if you would like to make the data portability right effective in such a case as connected car, you would need additionally a thick bundle of additional regulations about the scope of portable data, interoperability, security regulation, and also transaction costs, minimizing, standardizing processes. And this would look similar sector-specific regulation. Now, this is my last slide about general conclusions. I think very important is to see that data access sharing portability solutions require usually a broader analysis of the appropriate data governance solutions. And you have to really take into account the specific conditions in a sector and in a problem with a specific market phase for deriving what is a good solution. And this means usually that horizontal solutions, as for example, data portability rights as Article 20, have often problems regarding the effectiveness because they cannot be applied in a differentiated way enough. And you need additional solutions for interoperability, security, and privacy problems for making them effective. In addition to this, it is important also to look at other aspects. And one important point is in that respect that you have to look at that the effectiveness, I think, of privacy law-based data protection rights will always be limited. So in that respect, we should not overburden Article 20 GDPR too much for solving competition and innovation problems. So therefore, we have to think also about data portability outside of privacy laws. And therefore, I think interesting is the consumer data rights approach and also data trustee solutions and data intermediary solutions. For the connected car, it's very clear that a sector-specific regulation would be best for solving the problems. And I think that a reform, a far-reaching reform of type approval regulation would be most appropriate in that respect. Many thanks.
Thank you. And I have a follow-up question on the point you were just making. I'm getting an echo here, just a second. One of the people on the panel was asking about Article 102 TFEU. I think that's the dominant firm provisions in competition law in Europe. And how much would you consider dominant firm antitrust enforcement to be an effective way to get at this problem?
I think abusive, so the refusal to give access to data, if it's essential data, might be an abusive behavior of a dominant firm, Article 102. So theoretically, this is possible, and there is literature about this, also I've written about this. So far, there is not one case in which really this has been used, but it is theoretically usable. But I think in such a complex sector as a connected car sector, I think it is not enough to do this. So there's also in the amendment for the German competition law, which has been now enacted, there are also extensions really of these kind of competition law data access rights. But there's the same problem. It is very hard to do this and practically, and it cannot solve interoperability problems. So you can only solve certain aspects of getting access to data, but not really solving interoperability problems. And there is also another solution for data security problems, and because it's only looking at the data itself. And I think this is not enough. And it's also rather cumbersome for any kind of data claimants to use Article 102 for solving this problem.
Thank you. I'd like to note we've received word that Malte from DG Connect, his connection's not going to come back in time to do our panel today. We have three wonderful panelists, and next we'll move to Nizan, who's going to tell us about financial services, a very different sector from the auto sector. So please go ahead.
Hi, so I'm very happy to be here, and thanks for having me. And I'll talk about data sharing of consumer financial data. And I guess the main reason I have this first slide here is because in my mind, the very most important thing is to understand that we need to figure out safe and secure ways to enable consumers to control and share their own financial data. So this is sort of my first stop and something I'll mention during the presentation a number of times. But we have to figure out a way to regulate this, as we just heard, in a safe and secure way. So that's a key issue. So why open banking? Why are we seeing more interest in sharing data and transferring consumer financial data in recent years? So several things. First, it's all about the consumers. It's all about the customers. It's all about us. So we want to customize our services. We want to get specific types of custom tailor-made services that will fit our needs exactly and no one else's. And studies have shown that businesses will prefer a different provider, even if they're more expensive or a little bit more difficult if they're more to deal with, if they're more appropriately tailored to their needs. Also, financial economic inclusion. So connectivity is a big deal, and open banking services enable us to reach more clientele and bring more people under the financial service umbrella. Then we have innovation. These are new cutting-edge services. They're user-friendly. They're very sophisticated. Often they are answering or bringing solutions to questions and needs that weren't addressed before. And they're faster. And we like fast, speedy services. I think my slide disappeared. I don't know if everyone else can see. We like fast services that we can use quickly on the go, on our smartphones, on our tablets. And then usually they're cheaper because of regulatory arbitrage. So typically we see that financial technology companies are not as regulated as banks are. And so this enables them to offer services for lower fees. And then they're easy usually. Usually they're very straightforward, and even your older grandmother could figure out how to operate it on her smartphone, and it doesn't require too much to be able to operate these apps. And then last but not least, we've all been working from home, we're studying from home, we're spending much more time at home in the last year. And this is definitely, COVID has definitely increased the trend of online banking and digital banking and open banking services. So let me quickly walk you through how this works in the US. And then I'll talk about how it's done in the EU. So in the US right now, this is what happens. A consumer downloads a fintech app, and then usually they'll provide their bank credentials. They're very secure private bank credentials to the app that they downloaded. And then in the middle, between the app, the fintech app, and the bank, there's a data aggregator that stores those credentials. And then from that point on, starts copying and getting the data and sharing it with the fintech app automatically. That's called screen scraping, and that's the custom norm for open banking services in the US. Data aggregator is not really regulated, so they can share, sell, even carelessly dispose of data with not much liability. And then this will continue forever. So if I wanted to get rid of my PayPal app and deleted it from my phone, it doesn't mean that PayPal has forgotten about me. PayPal will continue screen scraping my information. In the EU, it's a little bit different because with regards to payments, you cannot use screen scraping. You have to use APIs based on the PSD2, the Payment Services Directive. But I'll talk in a few slides about why it's somewhat narrow and some trickiness and problematic aspects with that as well. So let's quickly talk about the banks versus the fintechs. Obviously, the incumbents, the banks are not too happy about this trend. And why is that? Because before COVID, we're talking December 2019, 40% of the logins in the US, the bank accounts were not made by consumers. They were made by data aggregators and fintech apps. This is a very massive volume, which you can only imagine increased drastically since this started. There are several problems with that for banks. First of all, they think that the data aggregators or the fintech apps often confuse or trick consumers using their logos and getting into their accounts and getting their credentials without really getting an informed consent. Even though technically you do need consent for these types of contracts, and in particular, also the PSD2 talks about consent, but it is questionable whether consumers actually understand exactly what's happening. Second, banks are pretty upset by open banking because they argue that this is problematic in terms of safety and security, which is not unique to banking. We see these issues all across different industries. Another interesting thing is that banks are much more subject to regulation that is anti-discriminatory in its nature, what you do with the information, how you can process it. And these fintech apps are usually not, which is something that could result in undesired consequences. And then there's the issue of them collecting basically all the data out there. And you can solve this issue with APIs because they're more limiting contractually of what types of data you can get. But with screen scraping, for sure, you cannot. And the amount of data that you get is pretty much everything under the sun, which is tricky for banks, but also for consumers. Then on the other side, the fintechs will say, in order to truly innovate and be able to create unique things, you need access to everything. And then you can figure out with big data correlations, cool features, competitive products for consumers, and much more. Last but not least, banks are concerned about losses. They will be liable. Most likely, most consumers will see them as the liable party if information or funds get lost. This topic hasn't gotten much regulatory attention in the US until recently. Why do I say until recently? Because in October 2020, two things have happened. First, the DOJ noticed the potential transaction that was about to take place with Visa being interested in purchasing one of the biggest US data aggregators, Pled. And that deal is no longer happening. It is canceled. And they were potentially going to buy them for $5.3 billion. And the DOJ had some issues about monopolistic power and in the payments sphere with regards to Visa's power. The second thing is the CFPB has issued a call for proposals. It has asked consumers and anyone pretty much interested in the topic, and this could be you guys watching this today, to submit by the first week of February comments about how this should be regulated in the US. And so we'll see what's to come, but they're definitely very interested in wanting to figure out how to best regulate consumer financial data sharing. As I mentioned, the two most common ways are screen scraping or APIs. APIs are the preferable way, obviously, in the EU based on the PSD2. The US has not viewed so far screen scraping as an illegal method, and it is perfectly permittable. In fact, some of the pushback that the data aggregators have gotten about the screen scraping, they push back by saying, oh, we're voluntarily going to try and switch our volume to APIs in recent years and maybe get to 3/4 of our volume be done with APIs, but who knows when and how. They're definitely safer and better. There are some issues with the PSD2, even though it is using the preferred method, the API. So first, as I mentioned before, it only deals with payments, and there are many other financial services that you get via open banking features now. It could be mortgages, it could be investing, it could be financial management, it could be foreign exchange, it could be lots of other different things which are not covered currently. Another thing is that there's some type of a conflict. 94% of financial services that were interviewed about this last year said that there is a conflict between the PSD2 and the Gdpr, with the Gdpr being a little bit more focused on the safety of the features, and the PSD2 encouraging more the data sharing. Another thing is that the data sharing is one way, meaning the banks are required to share with the fintechs, but not the other way around. And if you truly want to empower consumers, maybe you want to have all parties get a more broader picture and offer more competitive services and be able and enable the consumer to move and manage the information both ways. And then last but not least, even though there is that API requirement, most banks don't have internal APIs yet, so let alone external, which is something that needs to be further addressed. So the CFPB is really going to look into regulating this in the US, hopefully in the next couple of years, and we'll see where things are going. Currently, there's a section in the Dodd-Frank that generally states, Section 1033, that was put in place when this regulation was passed in 2010, that says that consumers should be able to access their financial data. Does that mean just the consumers? Does that mean third parties on behalf of the consumers? We'll see how this will be interpreted and determined. When they do, there are a few key issues that I just wanted to quickly point out that are relevant when we try to figure out a broader way to regulate all the different types of financial services that you could get via open banking when you share data, consumer financial data. And the first thing is really we have to figure out better the liability issues and how we make sure that the third parties are on the hook and who's going to be the gatekeeper. Maybe it should be the data aggregators that sort of figure out and monitor a way to manage them better, and so that the banks will feel more comfortable when consumers, rightfully so, turn to them as the deeper pocket. And then we have the issue of market power and innovation, proprietary data. And banks will obviously not want to give away everything they have and are worried about competition, but we need to make sure that they give what we need for them to give in order to empower the consumers. And there are certainly the antitrust issues that I mentioned before. And moving on, the flow of data that I mentioned, should it be bidirectional? This is what the recent Australian regulation is advocating for, and it's interesting, and I think it's an interesting concept that is definitely worth attention, having everyone share everything and kind of figure out a way to empower the consumer to manage that. And then we really need to focus on the issue of better guaranteeing that informed consent. The GDPR does a good job of that. The PSD2 does a slightly less good job of that. But it's something that is key also, especially in the US, with regards to the credential giving. And then the privacy aspect, how much of it is really more a privacy versus a security issue? Is there something that we need to be especially mindful of? In the US, there is no federal law creating a national standard for cybersecurity and for data security, and it's something that would need to be addressed as well in this context. And then the anti-discrimination issues that I've mentioned before, if this data is shared in an uncareful, unregulated way, technology is never neutral, and we know that there are all these biases put into technologies, and we need to make sure that it doesn't end up harming certain populations and going against desired goals. And then last but not least, what I mentioned before with regards to the new gatekeepers, maybe we should view the data aggregators or those intermediaries as parties almost analogously to the credit rating agencies in 2008, where we realized they have a significant role and we need to be better regulating them and making sure they do their job, increasing financial inclusion. And that's it. Thank you very much.
Thank you, Nizan, for covering that. Let me just point out, we've heard about the financial sector just now, which has very substantial rules in Europe under the Payment Services Directives, and increasingly will face scrutiny in the US. And as I was watching Nizan's slides, I was realizing you really need banking experts and expertise and security expertise and privacy expertise to try to get this right. And then we heard from Wolfgang about for interoperability, unless there's somebody with a good knowledge of the data flows in the sector, it's not going to get the kind of interoperability we need. So I'm seeing an importance of each sector having quite a different set of risks and benefits or set of regulatory things. So Reggie, could you please provide us your perspective from the CNIL and from your own experience?
With pleasure. So hello everyone, I'm Regis Chatelier from the CNIL, and in fact I'm Innovation and Foresight Project Manager at the CNIL, and we had the pleasure as the Foresight team to be proactive on the very specific topic of data portability since 2013, taking part to experimentation projects such as Mesinfo, which is a self data project run by the French NGO The Ping, taking part in My Data Conference, and also the CNIL led the writing of the Article 29 group guidelines for data portability in 2017. And lastly, we have organized an event on November 23rd in order to promote data portability and give insight to stakeholders and to share view with other regulators, with consumers associations, and with the competition regulators. And the same day, we have launched a public consultation on a draft of recommendation exercise of rights through an authorized representative. I will talk about it later in my presentation. But just, it was to make you remember that from the beginning, we think that data portability is a real opportunity for innovation driven by law. So first, we have the law, and then we have to innovate, I think. And innovators can use the Article 20 to create new services under the control of the individual, and both traditional data controllers and an ecosystem of innovators, startups, and so on could benefit. So let's go back to data portability and what it really means, and why Article 20 makes personal data usable by individuals. Just a few reminders, because if not everyone knows data portability in the Gdpr, but just to know that data portability is the right to receive the personal data in a structured, commonly used, and machine-readable format, then with a second right, which is to transmit those data to another controller without hindrance. And the third point is that you can ask to transmit directly from one controller to another where technically feasible. It's where we can have some interoperability. And when you talk about data portability, it doesn't mean all data, as Wolfgang said earlier. And it's subgroup of data of all the data the data controllers owns, or owns but control. So it can be the data actively and consciously declared by the data subject, the data generated by the activity of the person concerned, but it can't be the personal data which is derived and calculated or inferred. Why? Is to protect the core business of the companies, and only the raw data can be portable. And then it's not all the data, but only the data based on the legal basis of consent and contract. So that means that portability is different from the right of access, which is the right to read almost all the data controller owns control, but in this case it's different. But it doesn't mean that you can't have any opportunities to innovate. And to go back to the topic of this panel, we think that data portability is at the crossroad of regulation, of data protection rights, of consumer rights, and of competition law. But first of all, you have to remember that the right of data portability for the people is just a right for them to have control on their own data. That means that it's not only dedicated to competition, but it can have some benefits for the competition at the individual level. So, and this is different of several forms of portability, as sectoral portabilities. And in every case of portabilities, whenever one wishes to implement data transfer through ad hoc or regular forms of sectoral portability, it will always be a question of implementing the condition for the respect of the rights of individual and the Gdpr. But in the case of the data portability, in the sense of Article 20, even if it not deals with competition and consumer rights, it can have benefits effects on both rights, and not on the layer of the antitrust, but on the layer of individuals and the opportunity for them not to be to prevent lock-in effect in the different services. So we think that the data portability has the power to stimulate innovation by lowering the barrier to entry for new players. For example, if you for the users, you can use it to change services, to prevent lock-in effect, to try out new services, for example, to go to offer a photo printing service from its social networks, to limit dependencies on services. For example, if you don't want to accept the new privacy policy of a service and want to change, or if you face an imminent closure of the service, you can have the right to take your data back with you and to go to another service. One other opportunity is to avoid cold starts. And for example, if you run a new service, a new startup, for example, and you have a real good recommendation system, you can tell the people that they can go with their data, and so that they can use a recommendation system with data and not with a cold start. And one more solution would be to produce value-added services and to, for example, to allow consumer to transfer their purchase history from one service to another in order to obtain coupons or purchasing habits, for example. And the fact is that to promote data portability, you need to have use case, and we can go and have new use cases, because data portability doesn't mean the deletion. It means that you can ask for data portability from one services, but it doesn't mean that you don't have to be a client anymore of the service. So new entrants will thus be able to promote some come with your own data offers to facilitate the movement of consumers in the digital space. These are some examples. So at this moment, we have worked for years on the data portability, but we know that at this point, data portability is an obligation for data controllers and an important right for users, but the right is still rarely used by individuals. And we, for example, we only received a few complaints after the 2018, and at the same time, some data controllers had some questions around the portability and how did they have to make it available for the people. And that's why we have worked for some months on a draft of recommendation on the exercise of rights through an authorized representative. And the idea ready for us is to clarify the practical modalities of the exercise of the rights conferred by the GDPR to give to an organization such as personal clouds, PIMS, personal information management, data connector, that have been given a mandate by the data subject to organization holding such data. And in this recommendation, which is still a draft, I just present some examples regarding the security of the data transfer. And with 3 examples. First of all, is the identification of the data subjects. So we recommend that the mandatory the data subject their identification document should be only transmitted in support of the request in the controller through the real identity only in the context of which you have the data controller knows you with your own identity, for example, with a bank. But if the data controller only know you under your pseudonym, transmission of the identity document with the request may not be justified. It means that you can't ask some people to provide more information that they gave to register to a service when you have to give them the access to their data. It's an important point on which we have a lot of questions. Second point is dedicated to the API. Because as Volkan and Nizam said, the interoperability it's a real topic in the case of data portability, and we know that even the GDPR doesn't make it mandatory to give access to your data through an API, because it wouldn't be possible for anyone, because you have to understand that GDPR is a general regulation. For example, if you ask the data portability to your baker at the corner of the street, you won't have to ask them through an API. So that's why it's only a recommendation. But we observe that in case of to exercise the right through an authorized representative may be made through an API, because we think that it reduces considerably the burden of data controller in processing requests to exercise rights. So the CNIL encourages data controllers who hold the data to use this technology, in particular when they have to process a large number of requests to exercise rights, insofar as it allows the smooth transmission of personal data. And we're talking about, in fact, they have to use security measures which are proportionate to the risk that you have when transferring the data. And with the case of the bank sector, the CNIL notes that when APIs have been developed in order to comply with the requirement of PSD2 and that they function properly, the direct transmission of data from a bank to an account or service provider is technically feasible. That means that it could be possible for them to make the Article 20 data portability available for the people, even where the PSD2 does not apply, because not all the data controlled by the power bank are on the field of the PSD2, but sometimes there are other services with some data which are more on the GDPR and not on the PSD2. And last one, in the case you can have, I put the link. It's in French. I'm sorry, because we have to publish it only in French, but you can have access to it toward the recommendation of the website at the CNIL. And one more question is the security of transmission of data. And for what is transmission to end users, we recommend that the following measures be implemented by the transmitting entity to ensure the confidentiality of data exchange during transmission using encrypted encrypting communication with the state-of-the-art algorithms and keys, and to ensure that only the data subject can access the data relating to him or her. And third point, to implement a traceability mechanism illustrating the pace of the data. And for what is the transmission to the representative or to a third-party controllers, let Neil think that the following measures has to be implemented, which are the confidentiality of the data exchange during the transmission, which has to be by encrypting communication, the same as with the end user, and to establish some mechanism for mutual authentication for the entities concerned, using strong authentication mechanism to authenticate the personnel. So that means that you can have access to all of this in the recommendation, but the fact is what you have to understand and what the CNIL tries to do with this recommendation is that we are trying with this recommendation to provide all the information the data controllers and all the ecosystem needs to make the portability more easy for the people. And we know that the more you have some real services, the more the data portability will be effective. And at the same time, going back to the topic of the panel, just to remember that data portability from Article 20 is not the solution for any problem of competition. And I think it's part of the solution. And when we have to deal with data sharing, you can't give the burden to data portability to be the only way to deal with competition problems. But we think it's a really good way for the people, and it could be a good layer for these issues we have to tackle with. And that's why we will try to work on this draft of a recommendation. So these days we have received some contributions, and we will publish within months. I don't know exactly the date when we can publish it, so that people can have more information and can make the portability more feasible for anyone. Thank you.
Thank you very much. And for people, API stands for Application Programming Interface. People who work on portability have seen a lot of discussion of this kind of software that tries to get the data efficiently from the sending organization to the receiving organization. Régie, because we lost Malte from technical difficulties, in the last year we've seen the European Data Strategy, the Digital Market Act proposal, and Digital Services Act proposal. To the extent you've been able to follow those, what would you highlight for people about what seems to be new in the European discussion, or new points of emphasis in the European discussion about portability? Could you help us with that?
I can try. No, it's more. I think it's more on the Data Governance Act, which is trying to give some to try to give more power to the intermediaries on data portabilities, and that's why I think it's very important. It's a bit different because the Data Governance Act go in front of the Gdpr, so it's not going to change what I told you on the Gdpr. But what is interesting is that the main idea is to give more value to the sector and to provide some rules so that all the ecosystem of personal information management systems, personal account, and so on, can have access to some big rules so that they can respect and to notify to the Commission. Then to make the ecosystem more legally secured, so that anyone can use it. And that's why we are trying to do this. And there are still many questions, I think, and that's why you have certain types of intermediaries, and some are more or less easy to deal with, and some other need to be clarified for us. for example, the data cooperative or some services like this. But it's very important for us to follow all the works we had with the Data Governance Act. And if you go to the Digital Market Act, you will have some access to some data, which are not data portability, but that means that what I told you, that you have many ways to have access to the data, and in each case, we'll have to prevent that the individual rights are protected.
Right. Thank you. One question from the audience is, do the panelists know of any decisions or case law about the scope of data that falls under data portability? Have we seen cases or enforcement on that?
At the moment, at the CNIL, we didn't have a specific case. As I told you, we had only 30 complaints. So it's an important right, but only at its beginning. Nizan, if you want.
So yeah, in the US, there have been a bunch of cases filed against the data aggregators in the last year. I think more and more awareness is being given to this topic. Attention is drawn to the practice of open banking, of sharing consumer financial data, of what it means, of the potential lack of informed consent. And so some of the cases we've seen in recent months have sort of tackled that, and they were just lawsuits filed on behalf of banks or a group of clients, customers, against data aggregators or people sort of using these technologies without really explaining them properly to consumers or hurting the bank's rights, so to speak.
Right. So in the United States, there's case studies in the paper I talked about portability impact assessments. And there is a large antitrust suit going on in a debate between the automobile dealers, and the software companies that they rely on for their operating system. And so there's been active litigation about whether the antitrust laws are being violated because the software companies won't allow the data to be released, even though it's the auto dealer's own data in some ways. Please go ahead.
Sorry, I'll just mention something that is also a little bit less on data portability, but generally about sharing data. And there's a big case that went up the ladder in the US, which was LinkedIn against HiQ for screen scraping their database and taking information, and whether this was a permitted practice or not. And so far, it seems that to be the case that it was permitted, and it is okay, legally speaking, for HiQ and other types of data collectors to do that and screen scrape websites.
And so for people, screen scraping is the practice where I would give somebody the consent to get into the system on my behalf, and then the company would be taking data and putting it into their own software for further uses. A question for Reggie also is, many parts of GDPR involve fundamental rights where the charter of the European Charter is directly involved. Do you see Article 20 GDPR as being in that category of fundamental rights in the same way as some of the other rights in GDPR, or is this closer to consumer law, and so it's more within the scope of where the legislature makes decisions about what's best?
I think it's a part of legal fundamental right, and that's why I told you in my presentation that it's not only an article dedicated to competition, but the first right you have in data portability is the right to take back your data for your own use. You don't have to share it to another, and that means that the data controllers doesn't own your data. So you have the right to have it. But at the same time, we know that as it can be used, that it can prevent lock-in effect. It's a way to give you more control on data in a field in which you are a consumer, you are a citizen. Because I didn't tell you, but we have worked 3 years ago on a concept of citizen portability, on which you could use the data you have so you take back with portability to provide to some commons, for example, or to the public institution, so that they could use it for general interest purposes. So that's why we think that it's really a real part of a fundamental right, but the use you can, if you want to use it, it's much more dedicated to the competition, but not only. You can do whatever you want. That's why we think that it's a real field of innovation, and you have to innovate, and not only in the competition, but can be in many other sectors. One example was, but it was really theoretical. It was like, you have some patient associations. Sometimes they don't have the data, and maybe they could have their data back to create a command controlled by the association or the NGO, so that they can use it or for any research purpose, for example. That's why I think it's not just competition. It can be much more or less depending on what you do with data portability.
Wolfgang?
Yeah, I mean, the interesting question is, can you extend the data portability rights somehow? It's interesting that in the proposal for the Digital Market Act, there is one obligation now really about data portability for these gatekeeper platforms. And it's interesting that this is a data portability which focuses not only on personal data, but also on non-personal data, even aggregate data. And it's both for end users and for business users. So in that respect, what we have in Digital Market Act is much more than Article 20. And I'm a bit interested in the question, is it possible that you take the Article 20 and then extend it somehow to more data, or is this something then besides the GDPR? This is not quite clear to me.
I think if you go back to the GDPR, it's dedicated to personal data. That's why it should be done in another field, I think. And that's why you have, but it could be, I don't know, you have it's a theory, but the DMA or the Digital Data Governance Act, sometimes you can have some portability of non-personal data. It's different. But the GDPR goes when there are some personal data involved in the data sharing. Then you have to respect the GDPR. But it doesn't mean that only the personal data could be transferred or shared. So that's why I don't know. The GDPR is just there to protect personal data, but doesn't mean that you can't use the other data. But it's not the field of GDPR. That's just the point.
But this comes up to a question that Professor Inge Greif wrote in the comments, which is, I'll say it slightly differently. What's the role of the competition authorities and the data protection agencies and perhaps consumer? How can collaboration happen, especially if the new laws apply to non-personal data and personal data? How can the agencies collaborate, do you think, in these regimes?
In the past, we had some cases with the competition authority in France, and it's case by case because just to make it easy, the GDPR is a general law and for everyone, which has to be applied by anyone who control data, who collect and control data. And in the case of competition law, it's in France, it's a case-by-case study. And sometimes we had to work with in the past with the competition authority on a case on which they asked for the data portability from an energy provider to another one, which was a newcomer on the market, so that they can have some data on their potential clients to provide them some information. And we had to work together to make it possible for the people just to not to accept to have the data given to the newcomer, but to find some ways within it wasn't the GDPR in this moment, but it was the Loi Informatique et Liberté, which was the French law. But sometimes we can work together on specific case to find a solution. So that's why more and more, that's why we had invited other regulators, just to show that more and more personal data are at the intersection of many regulations, and that's why we are not alone in our boat, but we work with other regulators, and that's why it's more on a case-by-case basis, but we have to do this so that everyone can do their own mission.
And that was a feature in the Payment Services Directive as it was moving through the legislative process. The European Data Protection Supervisor, who's then Mr. Butarelli, was very concerned about some of the data protection aspects of it, and how to have the banking regulators who oversee the banks intersect with the data protection supervisors is something that was important for that sector. Stuart Dresner asked, and I think this is for Nissan, and then maybe I'll let each person have a final comment. Is there a risk that consumers might ask to use their rights of portability to transfer data from a regulated traditional bank to an exciting but unregulated fintech company? I think we spoke to this a little bit earlier.
Yeah, so of course, I mean, this is happening now all the time, and I think most consumers don't even necessarily understand the regulatory arbitrage point. They don't know exactly what the differences are in terms of the legal liability and requirements for traditional banks versus non-banks, which is part of the problem, right? So we don't really have that much of an informed consent with regards to what is happening with the data. What do consumers really want, or what are they consenting to, and what will be the potential consequences? And as I mentioned before, the Clearinghouse, which is the biggest banking umbrella organization in the US, have done a bunch of surveys checking to see if there are issues of liability when you do deal with a third party like that is exotic and cool and user-friendly and very innovative. Who do you think should be liable, or who you would perceive as the liable party? And by far, most survey takers have answered the bank. So I think this is really a tricky position for the banks, and part of explains to a great extent their resistance towards this, in addition to the competition aspect, right? Because they're on the hook for these potential losses or catastrophic consequences. So that is something we have to work on. I mean, we really have to figure out a way to better monitor or regulate, whether it's data aggregators that deal with these third parties so that they know that they can meet certain criteria, or figure out a way to do this in an appropriate way, because many of these fintechs don't have that deeper pocket and they're young, hungry startups. So we must acknowledge there's an asymmetry with regards to their potential liability capability, and figure out a way to address this prudently.
As we come near the end of our time, with either of the other panelists have any last point they'd like to make to the group before we finish today?
Yeah, I would like to emphasize again. So I think the data portability right of Article 20, I think it's a very important right, but it is not the main really instrument for solving competition innovation problems. And we should think much more about data portability right, or for example, about data trustee solutions for solving competition innovation problems, and not overburden Article 20 Gdpr. I think it's one of my main points that I wanted to make.
Just to tell you that I agree with you, and that it's complementary. And so, one more time, it's really important in the field of competition to take back the control of every individual, but it doesn't mean that it's the only solution to tackle the problem of competition. But it can be useful.
Go ahead,
I agree,
Lisa.
and I'll just add that I think no one wants to stifle innovation, and of course we want to increase competition. We just have to figure out ways to do it in a safe and secure way, but at the same time not let the incumbents discourage competition by using safety and security as arguments that will stifle innovation.
And maybe I'll wrap up and say the following. I've been working in this area of portability and seeing how each sector is so different and requires special attention when it comes to major sectors. That's a lesson from today. But also how it takes people experienced in competition and in data protection and cybersecurity and privacy and in these different things to come together to assess how to make these systems work. And so computers, privacy, and data protection. The computers part is going to require people with different backgrounds, I think, to work on these issues of portability so that we get the positive innovation and competition, but perhaps we control the risks to the individual rights and to security. We're at time. Everyone's encouraged to please go hear the closing remarks on a different channel. My thanks to the panelists very much, and we look forward to continuing the conversation. Bye-bye.
Thank you.
Thank you.
Thank you. Bye.